I'll just give a few more minutes for people to roll in. Again, Bahasa Indonesia translation is available, but through the Thai channel at the small glove on the taskbar. And may I just invite everybody to introduce themselves in the chat box, your name, your affiliation, and where you are calling from today, so we so we know who are in the room with us today. So you can choose the chat box to do that. In addition, you can also post your questions through the Q&A chat box, and then we'll circle back to the questions after the research team has presented their finding. Great. I think we are ready to start. Everybody should be on the call. Hello again, everybody. Good morning, good afternoon, good evening to you, and welcome to today's webinar on the recently launched report, The Impact of Strategic Human Rights Litigation on Corporate Behavior. My name is Art Prapar, and I am Senior Program Manager for Corporate Accountability at the Freedom Fund. I'm also here with my colleague, Mata Bislika, who has helped to organize this wonderful event, and we are delighted to host this great global conversation on strategic litigation. Again, before we get started, please introduce yourself in the chat box, your name, affiliation, and where you're calling from today. You can also post your questions in the Q&A box, and we can discuss them after the research team has presented their finding. Let me now take a minute or two just to say why this research is important to us at Freedom Fund and why we have commissioned it now. At the Freedom Fund, we've had a deep commitment to strategic litigation ever since our founding almost a decade ago. And the reason for that is simple. Our mission is to help end modern slavery. The latest figures show that there are estimated 50 million people living in modern slavery, and which about 28 million are in situations of forced labor. And most of that forced labor takes place in the private sector. The conclusion from those numbers is that too many companies are complicit in or willfully blind to forced labor in their supply chains. Given that the practice is prohibited globally, the other conclusion that can be drawn is that those companies currently feel too little pressure or incentive to change their practices. Is this impunity that enables forced labor to thrive in global supply chains? So the important question facing us is, how do we change that incentive structure? Our view has long been that strategic litigation is an important, though not the only tool to hold companies accountable. Over the last decade, we have supported more than 20 legal cases through our Corporate Accountability Initiative. We have funded activities ranging from research and investigation to evidence gathering and case filings. But there's one big challenge with strategic litigation. We know that when it works, when we get it right, it can be hugely impactful. But it can also be very expensive, time-consuming, and unpredictable. And sometimes even successful cases have negative impacts. So embarking on this kind of litigation has potential big payoffs as well as potentially big costs. So the purpose of this important report is to help us think about these strategic implications in a holistic way. While this report has been commissioned and published by the Freedom Fund, it has been entirely researched and written by our research partners. So on the call today, we have Professor Surya Deva and Dr. Ebony Birchall from Macquarie University Access to Justice Lab, and Professor Justine Nolan from the Australian Human Rights Institute at the University of New South Wales. Big congratulations to the authors team and big kudos to them. One final thing I wanted to say before turning this over to the research team is that we are very pleased to see that this research also shares insight for how the Global South actors, as potential initiators of litigation, can engage and maximize positive impact of strategic litigation. To achieve this, we must invest in long-term collaboration with local partners and help to secure funding and technical resources to initiate and sustain litigation with greater flexibility. And on that note, let me now turn it over to the authors so you can hear directly from them about the key findings of this report. We will then follow with a Q&A session, so please feel free to get your questions ready. Over to you, Justine, Surya, and Ebony.
Thank you so much, Art. My name's Justine Nolan. I'm one of the authors of the report, and thanks to the Freedom Fund for supporting this research. Each of us are going to take you through, in about the next 25 minutes, the findings of the report, and then we really look forward to your questions. So thank you so much for taking the time to join us today. As Art mentioned, strategic human rights litigation has been a key tool used by sort of rights holders, civil society organizations to influence corporate behavior. But there's been a lack of information into trying to understand how effective that strategy has been, and try to understand what the potential risks of litigation are and how these risks can be managed. And we were also interested in looking at under what circumstances will it be most effective. So the very high level big finding was that the report finds that litigation has been used successfully to promote human rights and shape corporate behavior, but the systemic impact on corporate behavior has, however, been slow and patchy and often inconsistent and ad hoc. So I'm just going to tell you at the start how we conducted our research, and then both Surya and Ebony will go in more into our findings and our process. First of all, how did we come up with our conclusions? The report combines both doctrinal and empirical research. So we reviewed a lot of the existing literature on strategic litigation more generally. We analysed, what others have said around it, and then we very much focused on adopting a case study method. We use the Business and Human Rights Resource Centre lawsuit database, which has more than 200 cases from all over the world. We excluded largely ongoing cases, and then we narrowed it down to 121 cases. And from that, we went down to a short list of 11 cases, which we did a deep dive case study. But the report references many more cases than that came up through interviews and our more general research. So what were we focused on in particularly choosing these cases? We wanted to make sure that we had cases that represented a diversity. So we looked at the nature of proceedings, the subject matter of proceedings, such as labor rights, modern slavery, environmental abuses. We had a selection of both civil law and common law jurisdictions. We chose to have a variety of cases which use different bases of litigation, so perhaps tort law, statutory provisions, some of the new human rights due diligence laws. We tried to get a mix of defendants and jurisdictions, so they're from different countries around the world, and different industry focus, whether it's extractive, agriculture, farming, garment, etc. And finally, we also tried to get a mix of cases from very early on in the business and human rights journey till now with it. And so the use of these cases sort of allowed us to unpack a little bit more the impacts and the effects of strategic litigation. To complement this, we conducted 25 virtual one-on-one interviews with key stakeholders that include lawyers from both those defending companies and those instigating action. Civil society, rights holders were amongst that. And then finally, we held an in-person workshop of about 20 experts mid last year in Asia. So the first question that we were tackling was this question around what makes litigation strategic. And our focus and definition on this was that the overarching goal of litigation in the business and human rights field is to change the ecosystem within which corporations are operating, and in turn improve corporate respect for human rights, strengthen access to remedy, and bring a systemic change to the way corporations operate in society. So for us, it was important to think about this broader ecosystem, corporate ecosystem, because this brings together a confluence of a network of factors and stakeholders that interact with the corporation. So when you look at the impact of a case, it's not just the one organization that is suing one company. There are often many other direct and indirect impacts in relation to that ecosystem. Next slide. So when we were starting to think about the challenges in this litigation, a major challenge is trying to come up with metrics that measure the impacts of litigation. And before Surya takes you through our impact framework, which we devised as part of this research, just a general sort of approach as to what we were thinking about with impact. So we noted that impacts can be both direct and indirect, and we'll talk about what some of those were when Ebony talks about the findings of our research. They may be immediate, So there may be an immediate compensation paid to rights holders, or it might be incremental. It might be many years later that legislation is changed or there are policy changes that are reacting to that lawsuit. Impacts are likely to be multidimensional, and they also mean very different things for different stakeholders. And on that same line, different stakeholders may enter the litigation or observe the litigation with very different goals. For some, they may be looking at an immediate result, but others may want the litigation to be pursued for many years so that a legal precedent is set. So all of these general factors then fed into the development of what we call our impact framework, which I'll now hand to Surya to take you through.
Thank you, Justine. And hello, everyone. It's a great pleasure to be joining this webinar, and it was wonderful to work with the team and Freedom Fund to do this research. So on this screen, you see what we call impact framework, and this is an original contribution, what we believe our research has contributed to. So as Justine highlighted, we adopted this ecosystem approach because it is very difficult to ascertain and separate distinct positive or negative impact of particular litigation, because the impacts are diffused, they're combined effects of many variables at play, and sometimes impacts may be noticed 10 years or 20 years down the line. And that's why it is critical for us to adopt a longer time span, larger perspective in the ecosystem approach. Now, before I give some examples of the positive and negative impacts and some case studies that we use in our report, let me highlight four unique aspects of this impact framework. First of all, this impact framework is adopting a holistic approach. So we don't assume that any litigation or any case for that matter is invariably going to result only in positive impacts or only in negative impacts. We found and we believe that the impacts are likely to be mixed, though that mixture may change. A particular case may bring, let us say, 80% positive impacts and very less number of negative impacts, or vice versa. But we believe that every case has the potential to bring both positive and negative impacts in a particular case. And that's where it is important for stakeholders to adopt a holistic approach to make that assessment. The second dimension of this framework is that it can be used both prospectively as well as in a retrospective manner. So let us say if someone would like to start litigation against a particular corporation, you may wish to make an assessment before starting the litigation. What are the potential positive impacts that you can wish to achieve, and what are the risks or negative impacts that are likely to happen? And then you can make an assessment whether it is really worth pursuing that litigation, because as was noted by Art as well, we do not believe that strategic litigation is the tool. It is one of the tools in the toolbox, and it has to be used in a very calculated manner in our view. At the same time, the impact framework can be used in a retrospective fashion. Let us say a foundation funded a particular litigation, and litigation has been concluded, some remediation took place, or there was partial remediation. Then the foundation may wish to assess, oh, was it worth funding this particular litigation? So after the litigation is concluded, you can retrospectively apply the framework to assess, was it useful to fund this case, and should we be funding some cases of a similar nature in the future? The third dimension I would like to highlight of this framework is that it can be used in both qualitative way as well as quantitative manner. In this report, we have used it in a qualitative manner, but we believe that the indicators that you see on this slide, you can also assign them values, let us say 5 points, or you can also adopt a differentiating variable value. Some points that you consider more important, you can give 5 points, but the other variables, you can give 3 points. And then you can come up with an assessment which is going to be quantitative. So we believe that this is the value addition of this. And the last point I want to mention is that this impact framework can be used by a range of stakeholders. Of course, rights holders and the CSOs and trade unions or other organizations or law firms supporting the effective rights holders, they can use it. but it can also be used by the defendants and the law firms supporting those corporations. It can be used by UN agencies. It can be used by policymakers. If the governments would like to change the legal and policy framework, they can use this impact framework. And of course, it can be used by the foundations and other organizations who are funding the litigation. Now, let me give a couple of examples of both positive and negative impacts before I pass it on to Ebony. In terms of the positive impacts, we felt that you see a number of indicators and variables here. Probably you can't read the text closely, but you will see that in the report. So one thing we found is that the litigation may trigger action outside the court. For instance, investors can become more conscious of human rights allegations and issues. And we found that this could happen even down the line. Like Unicol case is perhaps one of the earlier cases, started in mid-1990s. But then 20 years down the line, we see that the investors are taking a clue from that litigation that has unfolded decades ago. We also felt that the cases or strategic litigation can also shape corporate policies. That could be one particular company. An example is litigation against Casino Group, the French company. Because of the litigation, the company changed certain policies and started taking a little bit more carefully their human rights statements and policies. But we also saw more systemic and sector-wide change because of the Bhopal litigation. The entire chemical industry started behaving differently after the Bhopal gas disaster of 1984, and of course the litigation that unfolded both in India as well as in the US against that. So you can see that how that ecosystem changes because of litigation. An interesting finding of this research was that sometimes litigation is serving an education purpose. And the education, of course, could be of the wider community or the media as such, but it could also be of the lawyers and the judges who are involved in litigation. And one case, which is from Asia, in fact, is the case from Thailand, Mitropol case against the sugar company. And the lawyer involved in this case highlighted that how this one of the goals of the litigation was to educate the lawyers, educate the judges that how this extraterritorial litigation should be pursued, could be relevant in this particular context. And of course, the actual remediation is another variable, positive variable that is there. And we have a number of cases, whether it's a Vedanta case in England or the Nakala case in South Africa, where compensation resulted through that litigation. Now, when it comes to the negative impacts, we see that there are, again, a range of possibilities how the impacts could be perceived to be negative. I gave a couple of examples. One is the litigation under the Alien Tort Statute. Often that litigation is seen in a positive sense, but we see that we can also see the litigation ATS in the US as creating a regressive narrowing of the space, because almost everyone from everywhere wanted to pursue this litigation, and then resulted in US Supreme Court incrementally in a range of cases, narrowing down the scope to that extent that it is almost dead now to pursue that option anymore. So we believe that perhaps we need to be more calculated in terms of which cases to pursue. Otherwise, it could be counterproductive. It could backfire. The another negative impact is the SLAP, the strategic lawsuits to curtail public participation. And again, there are several cases, but one case is a very notorious case, I would say, we featured in our report, is the Thammakasat case from Thailand again, where the poultry farm person, the owner, pursued 20s, 30 cases, SLAP cases against the people who have made any allegations or criticism or pursued those cases. And of course, we need to be conscious of the cost implications. And the cost could be in terms of the money, of course, but the time is also a crucial factor. How long will it take the litigation to unfold, and whether the victims will survive or not? So Shell case, even if successful, both in the Netherlands, UK, or in the courts in Nigeria, the point is how many years it took. So I think those are the things that one has to carefully weigh. So now I would invite my colleague Ebony to share some findings and recommendations based on our research. Ebony, over to you. Thank you.
Thanks, Surya, and thanks everyone for being here. It's great to be with you all. So as we've just spoken about, we know that litigation can be hugely impactful in certain cases, but at the same time, litigation also has risks of negative impacts. So in this part of our report, we asked ourselves, what are some of the strategies that you can use to try and maximize the impact of litigation on corporate behaviour? And so these are the 6 strategies that we've drawn from our research. So the first strategy is to select the right case. Now, litigators will know that no case is perfect, and it's really quite difficult to predict at the start of litigation how that litigation will proceed over the course of the case. So what we mean by this is there are certain variables and factors that can make certain cases more impactful than others. So it's good to be aware of these different variables or factors. So I'll just go through a couple of factors now, and you can read the report to go through them in more detail. But the first factor is to think through whether the defendant is public facing. And that's because reputation matters to corporations. So if there's a business that has a public face and has a reputation, it's more likely that that type of litigation will have impact, because the pressure on the business's reputation is another way to pressure the business. The next factor is whether the allegations of abuse are perceived to be serious. And that's because it ties in with this idea that reputation matters. If a corporation is being the allegations against the corporation are more serious, then that means that there is more pressure on their reputation. Another factor to consider is whether the forum is suitable. So what we mean by the forum, we're talking here about the jurisdiction and the court where the matter is being held. Is it suitable in the sense of, is there likelihood of that case being successful and that that court actually creating orders that are then enforceable? And the last factor I'll mention here is whether or not the defendant corporation has a responsive culture. So what we saw in our research is that businesses respond differently to litigation. So some businesses respond in a positive way, and some businesses can respond in a really hostile way. So if you can identify by looking at previous cases, perhaps the corporation has been involved in litigation in the past, or any other behaviour that the corporation has had in the past, whether or not it's likely that the corporation will respond in a positive way, then that's something to think through. The second strategy on this list here is you should evaluate and manage negative risks. So as Surya's just talked about, there are several negative risks involved in bringing litigation. So when we're thinking through maximising the impact of litigation on corporate behaviour, it's obviously really important that we're aware of those risks and do what we can to manage those risks. So thinking through whether litigation is likely to cause harm to people, or thinking through whether the litigation is likely to set an unfavourable precedent. These are important considerations before you begin litigation. The next strategy is to collaborate with reliable local partners. So this type of litigation, what we found in our research, it's often transnational litigation, so litigation that spans across jurisdictions. And it's also litigation that often involves several stakeholders. So, there could be a law firm involved, there could be a civil society organisation who is supporting the affected community, there could be funders, there could be several stakeholders involved. So it's really important that those stakeholders are working together and collaborating well. It's important to think through whether that collaboration is sustainable in the long term. And it's also really important to assess whether you've got the required expertise to bring the case as a team, because if the case is crossing over jurisdictions, then you're going to need people in that team who understand the different laws in the different jurisdictions. Now, the next strategy is to manage expectations and competing goals. So as I've just mentioned, often these cases have several stakeholders involved. And with that comes the idea that there's often different expectations or different goals from each stakeholder. So you want to manage those different goals and expectations throughout the course of litigation. So thinking through whether there are common goals across the stakeholders is an important strategy. And the other thing that we think is really important that came out of our research, it's really important that the rights holders' views and perspectives and their goals and expectations are kept central to the litigation. And that's because rights holders shouldn't be, deprioritized and, allowed for a civil society organizational goals to take priority. The next strategy is to employ complementary redress mechanisms. So what we mean by that, Surya mentioned earlier that litigation is just one tool in the toolbox. So we see litigation working alongside other strategies. So, other strategies could be things like social media campaigns or, civil society activism or, shareholder activism, all those other sort of strategies that you can do alongside litigation. They're really important, and they will help maximize the impact of the litigation. So making sure that you're thinking through those strategies and being strategic with your strategies. And also just making sure that you're considering from the first place whether litigation is actually the best option to achieve your goals. Maybe there's another strategy that has less risk or less cost involved. The last strategy here is secure sustainable funding. So what came out through our research is secure and sustainable funding is really important and crucial to, bringing a successful case. And, you need to be working with funders who understand that litigation is uncertain, and that it's really important that cases have reliable and sustainable funding over the long term. So that's our 6 strategies to maximize the impact of litigation. And then our final slide for tonight is, Marta, can I get you to, thank you. The final slide is on recommendations. So the final part of our report, it draws out recommendations for 4 key stakeholders. So the first stakeholder are initiators of litigation. And what we mean by that is, law firms, civil society organizations, human rights defenders, people involved in commencing litigation. We recommend that initiators should treat as paramount the interests and litigation goals of the affected individuals and communities, because they are the people who the litigation is supposed to benefit first and foremost. And therefore, priority should not go to the strategic goals of the civil society organizations or other people involved. And initiators should build local collaborations and secure adequate resources in order to fund a successful litigation campaign. The second stakeholder is corporations. Now, they should respond to litigation in a manner that ensures respect for human rights. And obviously, this means, they shouldn't respond with hostility with things like slaps or, threats to security and that kind of thing. The third stakeholder that we talk about are funders, so litigation funders. We recommend that they should provide sustainable and secure long-term support for litigation investigations and for litigation generally, because that's going to help improve the impact of strategic litigation on corporate behaviour. And lastly, states. States should create an environment which is conducive to pursuing legitimate litigation as part of their duty to protect against human rights abuses by corporations. So that finalizes our presentation for now. I'm going to hand back to Art, who's going to host our Q&A session.
Thank you so much. That was brilliant. Thank you, Ebony, Suri, and Justine. And just to recap and remind people, please feel free to post your questions in the Q&A box so that we can have a deeper discussion with the research team. And again, the PowerPoint presentation will be shared to registered participants, and you can also download the full report. I posted the link to the full report in the chat box, and I saw that Suri also posted the link to the Access to Justice Lab as a resource center on the chat box. So please feel free to access to that. That was excellent. Thank you so much. Yeah, our research team. I think you have took us through, the framework. I think the opportunity and challenges of using the ecosystem approach to think about strategic litigation. You also talk about the risk and also potential rewards, right? The impact framework of thinking about strategic litigation, and also have given us some food for thought around strategies to help to maximize the positive impact and minimize the negative impacts, and provided great recommendations. I know that we have people calling in from India, Nepal, South Korea, Thailand, Kenya, Ghana, Indonesia, Australia. And when we engage with our partners in the region, obviously some of the security risk and the risks of SLAP have often been on top of the agenda around the risks of strategic litigation. You have touched upon that particular risk in the negative in the impact framework, but I wonder whether you can say a little bit more in terms of practically what works or what has been something that in terms of the practical aspect of preventing or addressing and mitigating those security risks in particularly for those regions and contexts that I've mentioned.
I can start. Thanks, Art, for the question, and then my colleagues can jump in. I will mention two practical tips that could be relevant. One is that if there is a significant risk, then those people should not be the plaintiffs. Don't identify them in the court litigation. They should be working behind the scene. They should not be exposed, because the fundamental principle is the do no harm principle. Because the risk of litigation or the outcome of litigation is always uncertain. But the SLAP outcome is more certain. So if we have to weigh these trade-offs, so I think that is one strategy we can adopt. The second is that we can also try to counterbalance the risk of SLAP with preemptive social media campaign. So if you can partner with the other organizations and try to put it on the table of the investors and consumers of that company who may potentially go for a SLAP case. So put them on notice already through your partners who can do that social media campaign or something else, so that those stakeholders who have a financial stake in the company, they may somehow discourage the relevant company to go off pursue the SLAP cases. Just two tips, but I don't know if Justine or Ebony wants to add something more.
Great. Thank you so much. That's really helpful. Just to underscore the importance of thinking through that. So I'm just scanning through the Q&A chat box. I think we'll talk about, so one from Mala, I think, is there any recommended enablers for the recommendations? Should generally doesn't have much effect with stakeholder. SLAP happens in many occasions, if not directly, indirectly. I think
Sure. I mean, one of the things I think that companies take notice of and is more effective is when they can see evidence of what other people have done before that. So a lot of people only sort of believe what they can, see, hear, or read about. So we can say what should happen, but the idea of this report is to try and gather examples where you can look through it and say, oh, this is a circumstance like this. I could make this example. I could bring this analogy and say, if it happened with this company, it should happen again with another company. So yes, we are using should, but we're also trying to provide you with examples where you can use those in your approaches, whether it's pre-litigation with companies or during that process.
Thank you. We also have a question from Virginia. Are there any types of allegations or cases in particular sectors that are more likely to yield positive or negative impacts? Any takers?
I don't know if Ebony wants to deal with this
Go
question,
ahead,
because
Ebony.
one issue, Ebony, we discussed is the public-facing companies, right?
Yeah, so if you look at factors that are useful to pressurize a company, that's the type of cases that you want to look for, things that have that additional pressure. So if the company has a public face, then there's going to be additional pressure on that company, because once the litigation is spoken about in the media, for example, that then adds pressure onto the company to change their practices. So that's an example of the types of factors that you look for when you're thinking about what case is going to be most successful.
Great. Thank you, Ebony. Sorry, the questions started to come in, so I'm just scanning through. I've got a question from Emilia, who posted in the chat. Emilia is from Indonesia. She works for GSBI. We have used several mechanisms such as the ILO, OECD, National Contact Point, and FLA, Fair Labor Association mechanisms. But all these mechanisms can only issue recommendations whose implementation is voluntary. Can the litigation process against a corporation that was won in the past be used for cases related to the same corporation?
So the way that litigation works is that it's binding on the parties to the litigation. So the particular case that you're looking at, the company that is being sued in that situation and the plaintiff are bound by the decision. So if there's another case that follows that, it might be related to the same company or different, that previous case would have set a precedent, so provide an example of how the result you would expect to come out, perhaps, but it's not binding in the same sense. So the mechanisms that you referred to, the ILO, OECD, FLA, are all really useful mechanisms that help shape behavior, decide the norms of, how companies should respond. But you're right, they can be loosely applied sometimes or not sometimes applied by the company. So the value of litigation when it works is that it's binding, but it's only for that particular issue for those parties to the litigation.
Surya?
I wanted to build on what Justine mentioned very rightly, that sometimes, in addition to what Justine mentioned, it could also be relevant that a past precedent can be used in a current or in a future case outside the court. For instance, if there was a successful case against a company, you can use that precedent in your engagement with the company that, look, that case was filed in the past, the company lost, you as the same company, or it could be a different company in the same sector. We have a similar set of facts here. So why don't you settle the case? Why don't you remediate rather than we going through the litigation? Or you can also make that argument when you approach non-judicial mechanism, NCP complaints or complaints to national human rights institutions, so on and so forth. Thank you.
Great, thank you very much. That's really helpful. I also have a few questions that was directly sent to me through direct messages. Let me just scan it through. So, okay, this is a good one. Do you think that the barriers to litigating using the derivative action or trying to establish the duty of care of a parent company towards a foreign subsidiary are increasing or decreasing, both substantively and procedurally? Justine, perhaps?
That's it's hard. It's sort of hard to say in terms of overall. So definitely, if you look at the last 40 years, sort of from the early 1980s to the early 1990s, there was a flurry of cases, particularly under the Alien Tort Statute. And then as the grounds of that statute narrowed, the cases started to decrease or slow down. In more recent years, we've seen an effort to use other countries' laws, particularly Canada, the Netherlands, the United Kingdom, for that type of extraterritorial jurisdiction. So the case numbers have started to go up again with it. So I think particularly we've seen a lot of advances in recent years. Now, report goes into this around that parent-subsidiary decision. The cases like Vedanta have been very influential in starting to change the shape of that conversation. In terms of lawsuits where you are trying to get liability for supply chain human rights abuses, that area is still pretty stuck. Not that it won't change, but it's much more sticky in order to get courts to look at a responsibility for a company at the top of the chain for what is happening to the workers at the bottom. So I do think that cases have been sort of up and down over the years, but there is a steady in sort of incoming cases, particularly around parent and subsidiary, but less so in relation to supply chain, where it's still considered very innovative to bring those actions.
Mm. Thank you, Justine.
And if I could, may I,
Yeah,
Art, is
please.
there
Yeah.
time?
Yep.
I just want to add, I think I fully endorse what Justine mentioned. But if you look at the barriers that continue to exist, that despite the duty of care principle, which is proving quite useful, the barriers in terms of the cost remain. Because how many cases you can pursue against a multinational in the UK? It has significant cost implications. And the leading law firm is Lead A. They will not pick each and every case. They will only pick a case which has high chances of success, first. Second, it must involve substantial amount of money because they have to survive as a law firm. So the question is also about the cost implications. So I think those barriers remain. And of course, there are barriers related to access to information. It is difficult to unpack the corporate structures and things like that,
Yeah.
Thank you.
Thank you very much. Really helpful. I see that there are a couple more questions coming in. So another one from Mala. While litigation is ongoing, is it possible to have a shell fund to support the victims during the course of the case?
I think that one might be to you in some ways. But Ebony, do you want to pick up on that point around sustainable and secure funding to support the cases?
Yeah, I think, it's really important to think about support of victims throughout the case because, we heard stories in our research where litigation became really difficult because while the lawyers were trying to run this case, people on the ground, the victims of the human rights issue, literally couldn't survive because they had no food and access to healthcare or whatever it was. So you do need to think about support for victims when you're designing the case and designing the funding for the case. But obviously, as we've just talked about, costs of litigation and, indirect costs of litigation are a huge barrier to bringing litigation. So it's really difficult and tricky. Yeah.
No, thank you. That's a crucial point about the sustainability of the funding, right? And the ability to also have some support for the the people, the rights holder who are bringing the cases throughout. I might just move us on to the next question. We have a colleague from the Seafarer Union in Jakarta, Sakti, S-A-K-T-I. His question is, how can we carry out litigation if there is an industrial relations problem with the ship owner from abroad? Meanwhile, his manning agency in Jakarta has gone bankrupt. Very specific.
I mean, in our report, we capture some of these situations. That's where the transnational litigation becomes relevant. So if the local company in Jakarta has got bankrupt, you can try to pursue a case in another jurisdiction against the parent company or against the potential investors also, or others who may be linked to that company in Jakarta that got bankrupt. But you need to make that connection. I think that's where the direct duty of care principle will become relevant, or that's where other principles of complicity will become relevant, or you can derive on some other principles. So I think that is where there are possibilities, but we are not suggesting that it is automatic that you can pursue that case elsewhere.
Thank you. And another question from Dr. Samuel Obiri. Are there international human rights mechanisms to deal with host governments of companies alleged to have abused the rights of citizens in where they operate? If yes, can they be joined in the litigation?
I can start this. It's a long answer, but I'll hand to Surya then. So there are many international human rights mechanisms where individuals can seek to bring a complaint around a human rights violation by the state. Some of these are directly under the treaties. So you would need to check if the country that is relevant is part of a particular treaty, for example, the International Covenant on Civil and Political Rights, for example, and the treaty mechanisms allow complaints to be filed. So that's different from litigation as such, but the International Human Rights Framework allows communications or complaints to be filed in various ways. There's also complaints that can be sent to the UN Working Group on Business and Human Rights, and I'll just let Surya speak to that one.
Yes, so these are special procedures of the United Nations, and they can accept complaints. And I think the one advantage they have over treaty bodies is that to pursue a complaint before the treaty body, that particular state government must have ratified that particular convention. Otherwise, you can't really file a complaint. But the special procedures can accept complaints against any state, even if that particular state has not ratified the convention. Let us take one particular country which has not ratified ICCPR in Asia. So it is possible to go after that particular state, even if it has not ratified ICCPR, and you can make an allegation that this government or its officials or agencies have violated Article so and so of the ICCPR. But in addition to that, I also want to add another dimension, which could be a response to the question, that it is very difficult to pursue a case as a joint defendant against a government in a foreign jurisdiction. And I think that is where international law and the aspect of sovereign immunity comes into picture. Let us say if we have companies operating in, let us say hypothetically in Thailand, you can pursue a case in Japan, in France, in Malaysia, or elsewhere against a Thai company. But if you want to bring Thai government as a co-defendant, that becomes tricky, and it is very complicated to pursue that path. I'm not sure if that was the intent of the question, but I wanted to touch upon that there are serious challenges in that path. Thank you.
Great, thank you very much. Another good question from the participants, from Simone, based in Nepal. The question is, what should activists do when legal system is weak? She heard from indigenous activists that they prefer to avoid any type of litigations because of high chances of unsuccessful. What could be a step-by-step approach to start a discussion on litigation in country with a fragile legal system, and discussions on business and human rights are still at the very beginning? Thank you.
That's an excellent point. And, this report is focused on litigation, but there are many other techniques and strategies that are relevant in business and human rights. And really, litigation remains perhaps more the exception than the norm. A lot what will happen is that what individuals may do is approach the company regarding mediation or negotiation, trying to raise the issues. You may also consider, are there other voluntary mechanisms that might be available to you that have been mentioned already, particularly the OECD complaints mechanism? There are many ways you can scale involvement and scale discussions with a company. It's unusual to jump straight to litigation. That's a more advanced strategy, and that's often many, many years in development. It is expensive, and as we say, it's often unsuccessful. But where it is successful, it has had large impact. But behind that, there are many other strategies that people are using, including looking to international norms like the OECD or the UN Guiding Principles to say, here are the standards by which we expect you to behave.
Thank you. Excuse me. Another question that has just been translated from Bahasa. The last time I heard that Germany, excuse me, Excuse me, sorry about that. The last time I heard that Germany had created a German supply chain law, is this mechanism the same as the previous ones, such as the OECD and the FRA complaints, etc.?
Maybe I can start with this one. So I think German due diligence legislation, which came into effect on the 1st of January last year, it is a bit unique because it opens at least two pathways for the affected rights holders. One pathway is that they could, with the help of a trade union or some other CSO in Germany, they could pursue litigation in Germany. That option is there. The second option is that those CSOs or affected rights holders could make a complaint to the regulatory body in Germany. So that is an administrative process by which they will try to regulate the conduct of the German company involved in the case. So there are two possibilities, litigation as well as the administrative regulatory complaint that could be made. And that could result in fines being imposed on the company and all that. But litigation will result potentially in compensation. So I think it depends upon which pathway you want to go for. Thank you.
Thank you very much. That was really, really helpful. I think we may have time for just one or two more questions. I'm just scanning the Q&A and the chat box here. Just maybe looking also at the questions that have been directly sent to me. I mean, I think you've been through the research, conducting interviews, and I think, one of the things that we also learn is that measuring impact for strict litigation is not an easy task. And I wonder whether you can speak a little bit about the limitations of actually evaluating and measuring impacts. So, for example, things like changing the corporate culture, or shaping laws and policies. What have been some of these major challenges, and what is kind of the next thing, or the thing that we need to keep in mind when it comes to measuring impact of strategic litigation?
I can just mention one and the others can jump in. I mean, I think one is to try and get that focus on causation. There may be changes that happen sometime after litigation, and then you're trying to trace that to the actual impact of litigation. As we mentioned, some impacts may be immediate, like the payment of compensation, but changes in policies, changes in corporate behavior may happen 2, 5, 10 years later, and that you will then find out that they were actually internal discussions which were related to that. So one is establishing that level of causation. And as you mentioned, measuring corporate behavior is difficult. We got some insights from speaking to lawyers who defended companies that we would otherwise not have found out publicly around that. So measuring the sort of corporate culture is very difficult to do.
Great. Thank you so much, Justine. We have now two more questions, which I'll quickly ask. Do you have examples of successful litigation brought against parent company in Australia?
Ebony, do you want to mention?
I'll quickly.
Sorry, go ahead.
Yeah. I think I will mention 2 points. First, it is not as developed as the jurisprudence in the UK. The duty of care principle and all that is not fully embraced by the courts in Australia yet. So I think there is that jurisprudential issue. But there are some cases. And one recent case that comes to my mind is, I'm forgetting the name of the company, but it was about the oil spill that impacted the seaweed farmers in Indonesia. That case was successful. But Justine, sorry if you want to jump in.
Okay, great. Let's go to the one final last question then from Emilia. Is it possible to file litigation against the same corporation or brand, but the case occurs in several different countries?
I can add something here. I think there's a couple of different ways to look at this question. So I was involved in litigation about a contraceptive device, and that contraceptive device was sold in several jurisdictions. So in Australia, in Canada, in other parts of the world. And so there was a class action in Australia, a class action in Canada, and, separate class actions about the same device. But that's because the harm was occurring in different countries. And so each case related to the harm that occurred in each jurisdiction. I don't think it's likely that you would be able to bring multiple cases in regards to the same harm, because the court system will say this case is better dealt with in this jurisdiction. This case is already being heard in another jurisdiction. We're not going to hear the case as well in this same jurisdiction. So there's different circumstances and ways to look at it.
Thank you so much, Ebony. That was really, really helpful. Well, I think looking at the time, I think we have to wrap things up. But there's been some excellent questions, and I think thank you so much for your active participation. We have people calling in from many different contexts, and it's really helpful to actually be able to understand. And I think the nature of the questions were very practical in terms of thinking through some of the strategies on strategic litigation. I'd like to take this moment to also thank the research team. I've said before that we couldn't ask for a better team to work with on this research, and your research has been hugely impactful and hugely helpful, for the ongoing conversation and the debate and the discussion in this field. So again, thank you to all of you, Justine, Surya, and Ebony. And then the final note, you can download the full report on the Freedom Fund website. I think my colleague just posted the link there. And thank you again for joining today's webinar. And I hope you have a great evening and a great day ahead. Bye-bye.
Thank you.
Thanks.